All right, sir, I'm detecting a bit of an attitude, and I've had a bit of problem with you all day long. I'd suggest you kind of take a deep breath and try to get rid of the attitude, because then if you don't, you may cause me to have to get an attitude too. So,
well, likewise, take that deep breath, do the same thing. You know what I mean?
Excuse me?
I said same, do the same thing. Take that deep breath. Goose fraba.
All right, Mr. Phillips, do you know what my title is?
I do, but that doesn't give you the right to belittle me or anybody else in your court. You know, you have a code of conduct.
Okay, I am finding your conduct contemptuous because you're interfering and disrespecting the process and the court. You are hereby fined for direct contempt of court, $100 cash payable in 1 week to the clerk of the district court.
That's fine.
And if I have any more problem with you, it's going to go up a little bit more. And if I have any more problem with you, you can go to jail over it.
I know this is being recorded, so I would like a copy of this because I'm going to take this to an attorney. That's fine.
$500 cash for direct court. And I am ordering you to surrender yourself by 2:30 today to the Butler County District Court.
I cannot do that.
Well, then send the sheriff out to get you.
You have been delaying the court the whole time.
All right, I've given you my order. Disconnect him from the call. He better be here or the sheriff will go out.
I will not be there.
You refuse to tell me your address?
It is none of your business. You will be informed through my attorney.
I think we're ready for William Wayne Phillips and Attorney Zolator.
Okay, let me get them in here.
All right, thank you. All right, we are on the record in 2024 TR 1376, State of Kansas versus William Wayne Phillips. Please announce appearances.
Jared Regier on behalf of the state.
And please, court, Mr. Williams appears in person with counsel Kevin Zolator.
Hang on.
This matter is set for bench trial today. And Mr. Regier, I see, has subpoenaed Trooper Andrew Lieber, who has been with us since 1:30. Now then, Mr. Zolator, does your client still wish to exercise his right to a trial?
No, Your Honor, we're requesting a continuance.
And for what reason?
We were just recently retained, I think, a few weeks ago.
Well, this case originated with some kind of traffic stop May 21st of 2024. The defendant had first appearance August 14th of 24. He appeared before Judge Rickey in custody September 11th, 24. He appeared before Judge Lee September 20th, 2024. Each time, this time he requested a continuance and the Chief Judge Rickey denied it. No, I'm sorry. Judge Lee denied it and set it for bench trial today before me. That was September 20th, the trial was set. The defendant told me back on August 14th he was hiring an attorney, which he has. And I show an entry of appearance filed October 24th. We're set for trial on charges of speeding 86 and a 65. We are also set for trial. Let me look at the amended complaint filed August 1st, see if there's anything still remaining. Count 2, driving while suspended after a prior conviction, a Class A misdemeanor. Mr. Regier, your response?
Your Honor, for the sole purpose of it, well, Your Honor, forgive me, Your Honor. I will, if I may, respectfully request 30 seconds.
Granted.
Thank you, Your Honor.
Now, your response to the request for continuance, Mr. Regier.
Your Honor, for the sole purpose, if if indeed the continuance is being requested, other than recently retained, perhaps there are some other reasons which I'm sure counsel can defer to the court better than I can. I would advise the court, in accordance with my duty of candor as an officer of the court, that I am not aware if discovery has been provided in this case. Certainly, legally, that is something counsel for the defense would be entitled to. However, to refresh the court's recollection...
You don't have to refresh my recollection, counsel. He entered his appearance October 24th, 2024. You can't tell me if you sent him discovery?
Your Honor, for my understanding is that issue is still outstanding, so...
I don't want it outstanding. I want you to check your file and tell me if he's had discovery and when he got it.
Your Honor.
Okay.
Or, Mr. Zolotor, you're an officer of the court. Do you have discovery and when did you get it?
Your Honor, I do not have discovery in my file with me, but I am not going to advise the court that I've not received it without checking the office file, which I can pull up now.
Meanwhile, Mr. Regier, if you have an answer from your end, I'd appreciate that.
And while I look, Judge, I think Mr. Regier was referencing other reasons. Obviously, we were just recently retained. I haven't had an ability to discuss with Mr. Regier possible resolution short of a trial. But, you know, all that I thought was somewhat implied in my statement that we were just recently retained. I don't think we've had sufficient time to do all the things normally that are done before a trial. But I am pulling it up now and I can tell you if we've received discovery or not. It does not look like on my end, Your Honor, we have received discovery.
Mr. Regier, how long does it take your office to get discovery? I mean, October 24th, he requested it, and it's now November, 13th? How much longer do you think you'll need to get that to him by computer?
Your Honor, under these circumstances, the state does not object to this matter being set over.
Well, my question was, and I don't know if Mr. Zolotor is the office attorney, I don't think he is, but we've had this issue before, and I have repeatedly ordered discovery go to the attorney, and what was it, 128 day? No. I can't remember the number of days that your office, even though I had ordered him multiple times to receive that, had still not sent him full discovery. I hope we're not going to get caught in another one of those situations where I order it and it's not done. And I'm concerned that now I'm hearing that after all this time, he hadn't even had it sent to him. So do you have any assurance, better than what we've had in that other case, that you'll send it to him, Mr. Regier? I frankly don't recall who the attorney was that we were having that problem.
Yeah, and from my end, Your Honor, and I've never had problems with Mr. Regier getting me discovery. My request was not based on, and I understand the court's frustration. I'm not trying to play both sides. We haven't had it. I wasn't complaining about that at this time. Frankly, I don't think a trial is going to be necessary if I get discovery and I'm able to talk to Mr. Regier, be more efficient that way. So that's my request. And I don't have any prior, I don't know what case you're referring to, but I would expect that I would get it in a short amount of time.
Well, Mr. Regier, do you recall which case I'm talking about?
Your Honor, not by number, although based off my records, it would appear that my office has communicated with Mr. Zolotor's office as recently as within the last 24 hours on the outstanding discovery issue. I would anticipate that being resolved in a timely fashion.
So we've had this bench trial set all this time, and they finally had a communication with him about discovery the evening before. Yes, I am frustrated. This is not the way cases are handled or to be handled. Particularly in this case, where the defendant has been told by multiple judges that we would have a trial. Judge Rickey said he set it, let me get to my judge. Judge Rickey told him he was setting it for a jury trial with me, and now I strike that. Judge Lee told him it was going to be set for jury trial. This has just been, he's seen 3 judges over the course of a number of months. He's told each of us he was going to hire his attorney. And now we come in here after he was specifically told to be ready to go to trial today, and he's not. And the reason you all know, I'm sure, that I am expressing frustration with this defendant is because he cannot do what courts tell him to do, according to my experience with him. And let's put that camera over there a little bit further so he can participate in these hearings. This defendant has told me in no uncertain ways that he doesn't have to give me what I ask for. He won't do it. He does not have to appear when I tell him to, and he has told me he won't appear when I tell him to. He has called me names, referred to me in a negative light, and he just does not seem to appreciate the judicial authority of me, of Chief Judge Rickey, or Judge Lee. He does not do anything any of us tell him to do, except I am impressed he shows up today with an attorney, one of which I know is very respectable and does do what he says he's going to do. So we are making progress.
To that end, Your Honor, at some point, my client would like to address you.
The other issue?
No, to address you.
All right. Well, at this time, I will grant the continuance at the defendant's request, but it's going to be the only trial continuance because I feel like this defendant has just been trampling over the judicial system for months now, just literally trampling over it. And I don't know, Mr. Zolator, if you've seen the videos from earlier hearings, but if you haven't, you really need to.
We have.
All right. This case will be continued. When's our next bench trial? Or does he want a jury trial? I have a jury trial in February.
Your Honor, I haven't discussed that with him. I am representing to the court that I do not think a trial will be necessary. If I must elect, I will have to go with a jury trial at this time because I have not talked to him about waiving his constitutional right, which I think is guaranteed because it's a Class A misdemeanor, not a Class B. If we set this for a status, I think we can probably get this resolved. I can't guarantee that. If you don't want to do that, I would request the jury trial set in February.
I will set it for jury trial, but you'll need, of course, make the written demand and so forth. Because I just don't want to let him, of course, like I said, he's got you now, and you're not prone to play the games that he has. So, all right. When's our next available status conference? Not until January?
And I apologize, Your Honor. I'm not available that date either.
Okay.
But if we can resolve this, I certainly will try to get a plea date before then.
Okay. Well, let's set it for pretrial February 3rd, 2025 at 9 a.m. and that will be by Zoom. The pretrial will be by Zoom. But of course, the bench trial or the jury trial that I'm setting will be February 5th and 6th, and that will be live at the courthouse. And the defendant, as condition of bond, is ordered to appear both dates and time. He needs to appear at the courthouse. I cannot trust him not to appear at the courthouse. So make sure he's here at least at the courthouse. Then if you want to be with him in person, that's fine too. Okay, so continued on your bond with those conditions. Anything else before we get to the other point at hand?
Not at this time, Your Honor.
All right. Now, the defendant was found in contempt multiple times and still wouldn't quit disrespecting and disobeying the court until eventually he was ordered to reappear later the same day in person at 2:30 p.m. He told me he wasn't going to. He wouldn't tell me where he lived, where he worked, blatantly refused to answer any questions of his whereabouts or anything I asked of him. He continued to smoke during the Zoom, even though he'd been told not to. He continued to eat and take an enormous amount of drinks. And he continued to get in and out of his truck and walk around the job site, take his hard hat on, take it off, walk all about, all during other defendants' hearings. And then when his case was called, that's when he started becoming blatantly, verbally disrespectful and telling the court how to do its job and not do its job. Throughout the docket, he was highly disrespectful and disruptive. He would talk over the court. He would make rude, personal, insulting, and disrespectful comments about and to the court. And ultimately, he was found in contempt to the point that he'd earned $500 in fines, and he was told to get that paid within a set time that he did not. He was told to appear later that day at 2:30 in person, which he did not. And then he saw Judge Rickey, Chief Judge David Rickey, on September 11th, and Judge Rickey found that he still had not paid the $500, and he gave him 1 week to get it paid, and in fact, he gave him an OR bond, which would have made it easier for him to pay the contempt within 1 week. He didn't pay it. He saw Judge Lee September 20th. Judge Lee said, well, he'll leave the contempt up to me when he sees me again. But he still hasn't paid it. Once again, he has totally disregarded court orders. So let's first deal with the consequences of his not paying, as multiple courts have ordered him to do. Then I want to address his direct contempt of not appearing when he was told to do later that day of August 14th. Now, whether we address Judge Rickey's orders that he violated, that we may postpone and let Judge Rickey decide if he wants to pursue that or if we want to go after him at a later date. But right now, I want to focus on his contempt of court, where he has not paid the $500. That's another act of contempt, and is not appearing as he told me he wasn't going to do and didn't, even though I ordered it. So let's start with why he hasn't paid, followed by why he didn't follow my order to appear. Counsel?
Well, first, Your Honor, I do know that he would like to apologize to you if you'd allow him to do that. And he doesn't have an explanation that's going to justify his conduct, nor is he going to try to. But I know he wants to apologize. I mean, the money's one thing. He doesn't have a lot of money, but his conduct is something he can't control no matter what. And if you allow him the opportunity to address you, I think we'd like to start there if that's okay with Your Honor.
Well, normally I appreciate a kind apology, but frankly, I'm not sure it's going to be sincere, and I don't want it unless it's sincere, Mr. Zolator. I sense if he makes an apology, it's going to be because his attorney told him that he needs to do that.
Well, Your Honor, I would throw it at your feet, let him apologize, and whether you find it sincere or not, I mean, I can't make that judgment for you. I think you know that, but I'm not trying to speak for you. I'm not sure what else I'm supposed to do other than let him. I mean, I will stand away and let him make his remarks.
All right. Go ahead, Mr. Phillips.
I would just like to say I am very sorry for my actions that day. Again, me apologizing doesn't give my actions justification in any means or in any grounds. I disrespected you, your court, your officer here, the DA, and I've been under a lot of stress, working out of town, very many hours with very little pay. And there's no excuse for it. I just more bad things happening combinedly, and it all came out in the very wrong place, wrong time with the wrong person. And I am very sincere in my apology. It's not when all this happened, I wanted to apologize, and even if you go ahead and read the other cases, when the other judge sentenced me when I was in Butler County, I was even apologizing then. I think I had the same district attorney there where I was trying to apologize, but at least to you, if not to you, to someone that can actually hear the apology without someone sitting next to me trying to say, maybe he had, someone tell him to do it or whatever. I am very sorry. I mean, my actions are out of line and there is no excuse for it. I'm truly sorry for disrespecting you personally and the court as well.
Well, I think the whole day of August 14th started off bad because I have a note that before court even, you had called one of the clerks and informed her you weren't coming to court because you were working in Independence, Kansas. And she explained to you that you could appear by Zoom and gave you the codes. And we weren't sure, based on your conversation, that you were going to appear, but you did appear by Zoom, and then the rest of it went from there. So why did you not, well, strike that, I don't. You still have not paid the $500, and no matter how sorry you are, your conduct was outrageous, and it's not going to be just excused. You've had since August 14th to pay that. You gave me the impression that you were a powerful employee of a well-to-do company and you were making good money, that you emphasized you were the supervisor. And you showed me by walking around that you did have a crew there. Now you're saying you're underpaid. Are you going to offer the underpayment as justification for not following my order or Chief Judge Ricky's to get that paid?
She's asking you why you haven't paid.
No, Your Honor. When we were in court that day, you said I had to pay it or do 3 days in jail. And that's the whole reason. I mean, if you go back in the Zoom videos,
Was that your understanding?
that was my understanding. That was my sincere understanding. So when I went back in front of that judge, I was asking the same questions, like, do I still have to pay this, or what's going on? Because it was 3 days, I did 6. I just don't understand. And he said, we're going to let you decide that, because I'm still willing to pay it. But my understanding.
Excuse me, sir, that is what the third judge said. Chief Judge Ricky told you September 11th, you would pay it within 1 week. He didn't give you any jail time, and I don't think I did either, because I told you to be here that day at 2:30, and you didn't show up or pay. So I don't buy that you misunderstood, and that somewhere are you saying you think you paid it because you got arrested and had to serve a little time before the judge saw you?
Well, yeah, I thought it was like.
So you not only misunderstood me, you misunderstood Chief Judge Ricky when he said you pay that $500 within the week.
Just
Is that a yes? Is that a no?
Well, I didn't know if I was waiting to see if I could. Well, yes, because it was the 5, and then he said something about $1,000, and I wasn't asking then. I'm confused.
And Your Honor, I certainly can help him understand the situation. I can tell the court that he's done 6 days, which wasn't part of the order. It was money, and he's done 6 days, which I think is, a bigger sanction than $500. He's certainly telling me, and I know he's got someone here with him, that they can get that paid, and they will pay it. It was, you can judge this as sincerity, Judge, and it doesn't sound like you're buying it. That's fine. I understand that. But this all resulted from his behavior that day. And I hope, at least, I did find that sincere, but maybe you don't, of the way his conduct, and he can't excuse that. The money, it sounds like he was confused whether you buy that or not. I don't know. But he did do 6 days on a driving while suspended case. It normally carries a 2-day minimum. And that's, well, yeah, but actual serve time, anyways. All
right, we won't get into that. Okay. Well, I think it's clear that I ordered him to pay $500, and it is well past the date he was to pay it. I think it's clear Judge Ricky told him to pay it. It's not what he thinks, it's what the judge says. So is he going to pay that today, counsel?
I'd pay within 30 days.
He does not have $500 today. It doesn't sound like.
I could pay something.
Can you pay anything?
I could pay something.
Well, you're able to pay a pretty prestigious attorney there, and you're able to talk the judge into giving you a $1,000 OR bond so that you can pay it, and you still haven't paid it. I question your sincerity if you intend to pay it. I thought somebody was implying you had someone there to help you pay it.
No, I was talking. If you can give me a second, Your Honor.
All right.
Your Honor, I'm being told they can make a $200 payment today.
And the other
And then
30?
they can pay that within, if you give them 30 days, they'd have the other 300 paid off.
The time he spent in jail was for failing to appear at a designated court date. It doesn't address necessarily any subsequent contempt. I will allow him to pay the $200 today with the remaining $3 to be paid in full by what date did we give him? February? I'm not going to give him that long. Within 30 days, he must have the $300 paid in full. That means it must be paid by December 13th, 2024, or I will find him in further contempt. And then I want to address his failure to follow my instructions to appear at the courthouse later that day. I will hold off on that issue until I see how he behaves from this day forward on this case and whether he pays as ordered. And this is the last one. He's going to be doing more contempt jail time if he doesn't get that paid as ordered in 30 days.
Understood.
Okay? So apparently he will stay out on his $1,000 OR bond that he convinced Judge Rickey to issue if he had that paid within a week. And he didn't. Anything else, counsel, that we need to address?
Not for purposes of today's hearing, Your Honor.
No, Your Honor. Thank you.
All right. Mr. Phillips, are you still employed by that same company?
Yes, Your Honor.
Yeah, why don't you tell me that since you wouldn't before?
Yes, ma'am. The same people that are doing your guys' water system here.
Okay, and where are you living now?
Uh,
Oh, stop, you're on YouTube. Is it the same address you put on that OR bond? That Judge Rickey had you sign?
I think I have a copy, Your Honor, picking it several.
Yeah, it is. It's the same one.
Yes. You don't want to.
Now, Trooper Lieber, I did not ask you, and you've sat here all this time since 1:30 or before. Are you available for a jury trial if it goes in February? Because if I need to set it for jury trial, it will be February 4th and 5th. We haven't gotten there, but if I need to, are you available?
Yes, ma'am. We'll make it work.
All right. Well, thank you for your patience and dedication to this case, for being here. I'm going to let you go at this time unless Mr. Regier needs you for anything else.
Not to my knowledge, Judge. I believe this is the last case on this afternoon's docket.
All right. And do you have anything else on this matter, Mr. Regier?
Not to my knowledge, Judge. I believe the court has already addressed the prior goings on in this case far better than I can.
All right. Mr. Zolator, anything further?
Your Honor, I was just conferring with the deputy. You just said 4th and 5th at the jury trial. We had written down the 5th and 6th. We just want to make sure.
It is the 5th and 6th, Trooper Lieber. It is the 5th and 6th. Now, one more question I have. I show that there was to be a cash-only bond of $500, but that he paid the $1,000 OR. So, Jen, can you look at that screen and tell me anything about why that's inconsistent? Is it because the judge changed it, maybe?
Your Honor,
Yes.
you're referring to his OR bond?
Right. So,
Judge Rickey set his OR bond, so he didn't have to put up any money. He just had to sign the paper to leave.
okay, he didn't have to put up any money, but he was ordered to pay the $500.
Yes. Now, if he fails to appear in the future, the county attorney can go after the $1,000.
Okay, all right. There you have it. So if there's nothing further, Mr. Zolator, you and your client are excused, as is
Thank you.
Trooper Lieber.
Thank you, Your Honor.
Thank you all. And this docket is adjourned for today. Did you
Is the clerk's office still open?
Yes,
Okay,
till 5.
all right. They're gonna make the payment.